Hey friends, welcome back. I'm Abigail, the Homeschool Hippie, and if you're new here, it's fantastic to have you. Please take a second to hit the subscribe button and the bell button down below so that you get notified of new content which is posted on Tuesdays and Thursdays each week. Today we're talking about the history of homeschooling in Missouri and how FHE, which is what we talked about in video 1, played an important role in the rights that we as Missourians have for homeschooling today. So laws for home education in Missouri have existed for over 150 years, but people didn't really start making use of those laws until in the 1980s. And people really began using those laws in the 1980s because they felt like students in the public school district were not receiving proper education and that the educational standards didn't meet what they wanted their children to learn, as well as behavior and moral standards in the public school versus those that their parents had for them. And because of this, a grassroots movement was started where more and more families began pulling their children out of public schools and deciding to homeschool them. But there arose some serious concern from school officials and the Division of Family Services, also abbreviated as DFS. And these officials all became extremely concerned about the type of education and the standard of education homeschooling children were receiving. So in 1983, a few years after this movement started, DFS began making threats to remove home-educated children from their parents' custody because they felt like they weren't receiving proper education. And it's unclear if this started from school officials or if DFS, or if it was a conjoined effort that started this movement and started the harassing and threats. But history does show that in 1983, that's when families began having children actually physically removed from their custody based on the fact that they were home educators. And that's really sad, you guys. I can't imagine someone coming in and being like, I'm going to take your kids away because you want to homeschool them. And so fear amongst home-educated families spread like wildfire because DFS would just come in and they would take these children away without any kind of due process. So this continued through 1984 and into early 1985. DFS and the school officials were standing on the ground that home educators had to provide, according to the law, substantially equivalent education. And it was just unclear what that was. What was substantially equivalent? Because the law did not specify. And so this left a very broad, open space for DFS and school officials to say that home-educated children were not receiving substantially equivalent education. And so the tension between the two groups continued to rise throughout that time frame up until early 1985. But as this tension continued to rise, the leaders kind of in the home education community started telling parents that they needed to document every encounter that they had with a school official or a member of the Division of Family Services because these families were being harassed. And so by documenting this and having witnesses say that they did see this, they were able to issue statements of harassment that were notarized by a public notary. And this was able to tell school officials and Division of Family Services, you're harassing me and you have no cause. But even then, some of those children were still removed from their parents' custody and the parents had to appear in a juvenile court system. And the issue here is the juvenile court system was actually designed for juvenile delinquent offenders. And so these families were having to go to juvenile court as though their child had done something wrong, but they weren't allowed to defend themselves. They couldn't defend their child, they couldn't defend themselves, they couldn't produce eyewitnesses, they couldn't produce materials, they couldn't show the work that their children were doing at home. It was a very one-sided case where the families would go in and DFS or the school officials would say, we believe this child isn't receiving substantially equivalent education and should be removed from the parent's custody because they won't re-enroll them in the public school district. And these motions were being granted and these children were being taken away. So much so that many people documented that DFS would come to their homes and take their children, or come to their homes and provide them a court date and say, bring bags because your child isn't coming back. You need to pack their things for when you come to court. And so families were being ripped apart simply because they wanted to provide good education and good morals and good Christian backgrounds to their families. And so this caused a very big wildfire, panic, and just fear that us as homeschoolers wouldn't be given the right to, one, defend our children, but two, educate them either. So during this time, leaders from the home education community here in Missouri started looking for a lawyer. And eventually they settled on a lawyer out of St. Louis, and his name was Arnold T. Phillips. And the sad part about this is he didn't have very good knowledge of the homeschool community, the homeschool laws, what was happening here at a state level, or even what the national laws or what was occurring on a national level was happening. And so the homeschool community had to catch him up to speed. And once he was finally caught up to speed, he believed that the home education community could file a class action lawsuit against the school officials and the Division of Family Services for removing their children without proper care or a proper hearing. So they began looking for families throughout Missouri who had documented harassment diaries and had been issued or had issued statements of harassment with the notary signature, and then had eyewitnesses to back up their claims that they were educating their children, but they were being harassed simply because they were home educators. And eventually, this is kind of where FHE comes into play. They were formed and they agreed to be a listed complainant in the class action suit, as well as to find the families that would best show what they were trying to accomplish with this class action suit. And so 25 families were initially listed, and they narrowed them best down to 2 that would show the most evidence for the case that they were trying to argue. And then in 1984, a suit was filed with the U.S. District Court on behalf of David Ellis and Charles Bowles families and FHE against 3 school superintendents, the head of the Division of Family Services, the Commissioner of Education for the state of Missouri, and 20 members of the DFS and juvenile court system. The suit initially sought a multi-million-dollar damage for violation of civil rights. And so the argument began, and the home educators were arguing that this term substantially equivalent was vague, and because it was so vague, it was a violation of their rights to remove their children, because what was substantially equivalent? Was that 8 hours a day? Was that the knowledge that they should have? Was that the, what was the substantially equivalent? And this was the argument that they took forward with them in the lawsuit. I'm going to give you guys a little quote. The plaintiffs argued, in all its applications, directly restricts protected First Amendment activity and does not employ means narrowly tailored to serve a compelling government interest. Eventually, the plaintiffs dropped their request for the multi-million-dollar damages as a show of good faith that the state of Missouri, the education board, the Division of Family Services, and the government or the school officials would come up with a law that allowed the freedom for home education, would ensure that these children were returned to their home, would also ensure that children were being educated fairly. Once this happened, they stopped arguing that it was a civil right, and they directly fired at the state statute for home education. And the state requirements were, quote, during the usual school hours, which shall, in the judgment of a court competent jurisdiction, be at least substantially equivalent to the instruction given to children of like age in the day schools in locality in which the child resides. So obviously that's really vague. Like, what? That doesn't even begin to say like what kind of education they need, just that it should be equivalent to what they would get at school. Well, who decides what's equivalent? So during this time, Phil Lancaster wrote a book, and this book was titled Academic Freedom, Home-Based Private Education, to inform and educate the legislators about our desires and to summarize our position as home educators. And then during the 1985 to 1986 legislation session, the home educators had won their case that this law was vague and it was a violation of their rights. And so the legislation branch was ordered to create a new education law that would be less loosely worded and more understood and able to be followed. And so many bills were brought to the table and didn't make it, including one named Senate Bill 666, specifically to be heinous towards the homeschooling community, to say like, haha, you're all a mockery and this is what we think of you. But unfortunately, it didn't make it very far. It died a very quick death, and the guy who wrote it was not very well looked upon. And then State Senator John Schneider D. proposed a bill that eliminated the words substantially equivalent and protected home educator rights, but ultimately it didn't win either. It wasn't voted into law. And so Mark Mabon, Tom Dreschel, and Steve Fortney and Jim Rogers were behind a last-minute negotiation that allowed minimal state requirements, removed the rights of DFS and school officials to investigate home education and to determine if children were being educated properly within their home, and instead gave that power to someone else. And in the end, it did not pass, but Senate Bill 795 did pass. And although it wasn't as loose and free for home educators, it was in the end a fair bill. And so FHE did not want to sponsor the bill in case they needed to come back and say like, this isn't working and we can't be a part of this bill if we're gonna have to fight it later. So they didn't sponsor the bill, but they also didn't try to fight it down either, because it was pretty fair for both parties. So FHE was instrumental in this process, because not only did they help find the families and find the lawyers, and they did a lot of lobbying when this new bill was being written and how it would be worded, and they also included Phil Lancaster in his book that helped educate the legislators and tell them where we stood as home educators and what we needed and what would be fair for us and them. And in the end, a good negotiation was something that was fair for us and fair for them, and that's what passed. And it has provided wonderful and beautiful laws that make our great state here so easy to homeschool in. And so with that, that's kind of the end of the history session. This is kind of a very condensed version, but I wanted to get the important facts out for you guys and let you know who the key players were. And on our next video, we are going to talk about HSLDA, the Homeschool Legal Defense Association, and we are going to talk about their purpose and what they do. But that video will air 1 week from today, because the next video that comes up on my channel is going to be a tribute to my baby turning 1. And you guys, I'm not ready. I could just cry talking about the fact that she's going to turn 1. But her happy birthday is on Saturday, February 16th. And we are going to have a party, and you guys will get to see a tribute video with some of her birth photography and our favorite photos up to her turning 1. We will not be vlogging her birthday party. I really just want to be able to focus on her and enjoying this beautiful milestone that she's coming upon. So if you are specifically here for the Missouri Homeschooling 101 series, I will be back next Tuesday. But if you want to see a beautiful tribute to my daughter, please come back on Thursday. And with that, peace, love. I hope you guys have a fantastic day, and we will catch you in the next one. Bye.
Higher ground. May you always keep your head held up high. Pretty little thing, you're a diamond in the rough, shining from within. I can tell that you're tough.